Honourable Phil Goff.
Mr Speaker, can I begin by correcting the member who's just resumed his speech, Tim McIndoe, who hasn't been in the House very long, so I guess he can be forgiven for not knowing. Far from leaving the justice system in disarray, the two biggest pieces of legislation, the Sentencing Act and the Parole Act, were both passed in 2002. Shortly after that, there was a Victims Act, also passed by the Labor government. That replaced a previous Victims of Offences Act, also passed by a Labor government in the previous term, Mr Speaker. So I reject entirely the facile arguments raised by Tim McIndoe that the system was in disarray. In fact, the pieces of legislation that are most important in the justice system today were passed under the last Labor government, not the pieces of legislation that have gone through in the first 3 years of the National Government that are basically window dressing that do absolutely nothing. And secondly, Mr Speaker, the member had the effrontery to tell the House that this legislation is so important it must be passed by tomorrow. You know why it has to be passed by tomorrow, Mr Speaker? Because with 3.5 years' notice, the government did nothing, knowing full well that the existing legislation expires tomorrow. That is political mismanagement. This government should have acted in a timely way to get the new legislation into the House. And the fact that we are doing it now, the day before the recess, is an indication not of filibustering at all. It's an indication of incompetency in management of the legislative agenda. Mr Speaker, this is a simple bill. It would have been unnecessary if the government had acted in a timely way. That is, they've had 3.5 years to come up with a replacement legislation, knowing the existing legislation had a sunset clause. And that should have happened, Mr Speaker. Mr Speaker, the one advantage of that is that the Minister of Justice gave a commitment earlier in this debate that I hope that she intends to honour, that she would use the year ahead to review the legislation and to determine the most appropriate way of replacing it. Now, I know there's a piece of legislation that the government has drafted. It doesn't do the job that I believe needs to be done if we are to put victims at the centre of the justice process. Mr Speaker, at the third reading, I think it is important to give the context of the existing legislation. It was passed in 2005 and it was passed when I was Minister of Justice. That was because we had an unprecedented number of claims being made by inmates within the system for compensation for a system that had not upheld their rights. Now, I don't justify the fact that the corrections system in its behaviour modification regime got it wrong. We are bound by international law on this, not recently, but for the last 40 or 50 years. Now, Mr Ryle's in the House today, and he might remember this little speech that he gave at the time. He was the leading speaker for the National Party in opposition. He said they were opposed to the bill. They believe that the payments should be blocked, stopped and wiped out. Quote, "We do not believe that New Zealand should be constrained by the figment of what the United Nations may or may not state in various conventions." That figment, Mr Chairman, was a series of the most important human rights standards passed by the international community, signed, ratified and observed by New Zealand for 40 years and observed by all of the countries that we would like to compare ourselves with. United States, United Kingdom, Australia, Canada. So I suppose what I should say, while Mr Ryle's in the House, after that rabid statement, I am pleased that this government has at least resiled from Mr Ryle's awful claims and acknowledges that you need to uphold the international standards that we have committed ourselves to. So I suppose, Mr Speaker, that is progress of some sorts. I think that, notwithstanding the fact that the inmates concerned had committed some of the most serious crimes, that they had been amongst the most recidivist of offenders, we nevertheless have to have a system where we set rules and the people that we put in charge of the corrections system have to follow and observe those rules. I did not believe, however, that the only way of doing that was to provide huge compensation payments to those inmates. And I'll tell you why I thought that at the time. First of all, I thought that only in exceptional circumstances whereby there was no other proper remedy of the breach of rights should compensation be granted. And I hold by that statement. And secondly, Mr. Speaker, I think that it was really important that if these inmates were to receive compensation, the victims that they had created, people who were badly damaged physically, who had had their property destroyed, who still bore the scars of the offending by this group of people, should not be left out in the cold, while the inmates whose rights were also abused came into a huge sum of money. Not one of these offenders would have given reparation to their victims. They left behind people who they had badly damaged without any sense of remorse, without any attempt to make a payment, and no payment ordered by the state because they were on their way to jail. So here were the victims of these inmates who had been badly abused, much more so than the inmates themselves, and they were getting nothing, while the inmates were going to come in for a windfall. And I thought that was wrong, and I still think that is wrong, Mr. Speaker. So what we want to do, and what we did in this Act, was to restrict the circumstances for payment and to allow the victims of that offending to make a claim against the inmates if they got compensation. Mr. Speaker, we put a sunset clause in. Why did we do that? Because, well, the principle was right that the victims should be properly compensated for the injustice done to them by the inmates. We weren't sure that the mechanism was going to achieve this. And I'm grateful that the Minister came into the House and said what this Act had actually done. And it had enabled five victims of inmates, I should say, to receive compensation, I think totalling around $45,000. Well, that's good, Mr. Speaker, but it's tiny. It's not a remedy to the wrongs done to victims across the board. And my concern at the time, and my concern now, is that I was dealing with a fraction of the victims of offenders. And there were all sorts of other circumstances that were arising. Some people in jail were writing books about their crimes, and if it was a sufficiently dramatic and dreadful crime, they would come into a whole lot of money from the proceeds of selling their book. Where is the justice in that? Well, their victims are left without anything. What about the inmate who receives a bequest? They come into a whole lot of money that they've inherited. They're now in a position to set things right for their victims, but there was no requirement for that. There's another set of circumstances, and I was reminded of this in the paper the other day, where a former gang enforcer is now living a relatively respectable life as a businessman on Auckland's North Shore. He has a whole trail of victims behind him. He has now got the means to set things right. He will never have shown remorse, and he will never have given any compensation to his victims. And what I say the Minister should be doing in this year that we've got now is to think laterally, to look at other systems where victims are better treated than they are in our system. You know, we have court cases, and they're described as, if you'll excuse an example, the state against Roy. So you've got the state, which is the prosecutor, you've got Roy, which is the offender, but nowhere in that case is the name of the victim mentioned. And we say the victim should be at the centre of the process, not an adjunct. They should be there, and you get real justice when you follow a restorative process. What does restorative justice mean? It means an expression of remorse. Maybe that's a bit easy, but it means that the offender is required to the extent possible to set to right the wrongs that have been done. And I would hope, instead of this half-baked measure that the government wants to introduce, we'd look more widely at a system whereby we respected the victim and we required the offender to put things right, even if it is some years after the offence was committed. Because at the time of conviction, hardly any serious offender will be able to make payments to the victim. But if they're in the position later on, why should they not, even at that stage, be required to put their wrongs to the victim right? So I ask the Minister to uphold the undertaking that she's given to the House, to talk to all sides of the House, to try to come up with something that does actually provide genuine justice for their victims. This is an opportunity, Mr Chairman, Mr Speaker, and we should take that opportunity.
Speaker.
Julianne